A mile and a half of freight cars sits motionless on a rural crossing. The engines are running. Nobody is aboard. It's been there for 9 hours, and nothing about it is illegal. In Leggett, Texas, on a summer day in 2022, a Union Pacific intermodal train ground to a halt across Glover Road. The crew, bound by federal safety caps, set the handbrakes, locked the cabs, and departed in a transport van. They left the cargo blocked on the tracks, waiting for a relief crew that was hours away. Because the crew followed standard securement procedures, this blockage was entirely lawful. No local sheriff could issue a binding citation, and no state agency had the power to force the train to move. Yet legal status does not prevent public harm. While the train sat, a 3-month-old infant required emergency medical care on the other side of the tracks. Paramedics faced a 30-minute delay, unable to bypass the steel barrier. The event reveals a stark gap in accountability. A train can be completely compliant with federal safety laws while actively endangering the community it divides. Inside the locomotive cab, this situation is known by a precise shorthand. The crew has gone outlawed, dead on the law, or dead on hours. These terms do not describe an engine failure or a mechanical defect. The locomotive remains fully functional, but the crew's legal authority to operate it has expired. Under federal law, the moment a crew hits their 12-hour consecutive duty limit, their clock stops. They are legally barred from moving the train even 1 inch further, even if it is currently occupying a public crossing. This sudden halt is the result of strict legal boundaries, often compounded by severe operational constraints. Railroads must navigate constant challenges, including signal failures, dispatch congestion, and acute crew shortages. While splitting a train to clear a crossing seems like an obvious fix, doing so is a hazardous, slow process that requires additional personnel, precise air brake tests, and significant safety risks. When these delays pile up, the train must be secured exactly where the clock runs out. The crew must step down, leaving a fully operational, multi-thousand-ton machine idling on the tracks, legally frozen in place. Under Title 49 of the United States Code, Section 21103, the 12-hour consecutive duty limit is a hard statutory ceiling designed to promote the safety of employees and travelers alike by preventing the dangers of sleep deprivation. The origins of this federal safety net date back to 1907, during an era of rapid industrial expansion when rail workers routinely faced grueling, unregulated shifts. Recognizing that sleep-deprived crews posed a severe threat, Congress intervened to establish the first hours of service standards. These standards were substantially revised in 1969, and national safety awareness intensified further following the 1972 Chicago commuter rail crash. In that disaster, an Illinois Central train overshot a station platform and collided with a following train, killing 45 people and injuring hundreds more. The tragedy demonstrated how a single fatigue-induced decision can result in catastrophic loss of life. To prevent such disasters, the current federal framework mandates a strict 10-hour uninterrupted rest period after a 12-hour shift. This recovery window is backed by modern biomathematical fatigue modeling, ensuring that engineers and conductors have a genuine physiological opportunity for sleep-related recovery. But while this safety rule protects lives by enforcing a mandatory rest period, the law contains no spatial guardrails. It dictates exactly when the crew must stop working, instantly at the 12-hour mark. But it does not dictate where the multi-ton machine must park. If the safety clock hits 0 while the locomotive sits across a busy highway in a rural town, federal law requires the wheels to stop, regardless of the gridlock left behind. When the 12-hour limit expires, the train crew cannot simply turn off the engine and walk away. Under Title 49, Section 232.103 of the Code of Federal Regulations, they must execute a precise, mandatory securement procedure. The conductor steps down onto the ballast, moving along the side of the train in the dark to manually apply heavy physical handbrakes on a specific number of cars, calculated based on the train's weight and the grade of the track. Each handbrake must be spun tight by hand and tested to ensure the massive weight of the consist cannot roll. Inside the cab, the engineer sets the independent and automatic brakes, securing the locomotives before calling the dispatcher to log the exact time of securement. This communication triggers a logistical scramble. The crew is now in limbo time, a regulatory status where they are no longer legally permitted to perform any covered service, yet they cannot leave the site until a transport van arrives. If a replacement crew is not already waiting, the train must sit. Locomotives continue to idle to maintain the air pressure required to keep the emergency brakes engaged. Splitting the train to clear a crossing is a slow, complex operation that requires additional air brake tests, introducing new safety risks and hours of delay, especially with severe crew shortages. Instead, the crew waits in the cab for a deadhead van to carry them to their relief point. Until a fully rested, qualified replacement crew is transported to this remote location, the secured, multi-thousand-ton train remains exactly where the law froze it, completely blocking the crossing. In the early 1990s, an executive named E. Hunter Harrison began implementing a new operating philosophy at Canadian National Railway. Known as Precision Scheduled Railroading, or PSR, this model eventually spread across nearly every major Class I carrier in North America. The business logic is straightforward. Keep assets moving, minimize the time rail cars spend sitting in yards, and operate with fewer locomotives, tracks, and workers. By scheduling individual cars rather than waiting to assemble massive, unpredictable trains, carriers sought to lower operating ratios and improve profit margins. This model changed more than schedules. It altered the physical makeup of the freight network. While the Association of American Railroads reported the median Class I train length in 2023 at 5,300 feet, the extremes have stretched significantly. Consists exceeding 10,000 feet and sometimes reaching 15,000 feet have become common. Longer trains allow railroads to move more cargo with fewer locomotives and less fuel, representing a massive win for productivity. But these supersized trains also carry operational trade-offs. They require longer distances to stop, put immense strain on air brake systems, and are far more difficult to split or move into sidings when something goes wrong. At the same time, staffing levels fell. A Government Accountability Office report found that the 7 largest freight railroads reduced their total staffing by approximately 28% between 2011 and 2021. With leaner workforces, relief pools shrank. Now fewer standby crews are available to cover a larger geographical territory. When an active crew reaches its 12-hour limit, the wait for a replacement van or a fresh crew is often prolonged because the nearest available workers are miles away, already assigned to other duties or resting. To be clear, these operational changes do not directly cause every single blocked crossing. Trains still stop due to mechanical failures, broken signals, or dispatch congestion. And when a train blocks a road, splitting it in half to clear the path is not a simple task. It requires the remaining crew to walk the length of the train, manually apply handbrakes, bleed air lines, and conduct mandatory safety tests, a process that can take hours and exposes crew members to severe safety risks. Yet by running longer consists with fewer reserve employees, the modern operating model ensures that when a delay does happen, the physical footprint left behind in a divided town is much larger, and the wait for help is much longer. In Hammond, Indiana, on April 28, 2023, a stationary Norfolk Southern freight train severed the south side of the city, blocking 5 consecutive intersections. Local dispatch logs and fire department after-action reports document the precise cost of this barrier. An ambulance responding to a cardiac arrest was delayed by 12 minutes. On the same day, a fire engine heading to a structure fire on Main Street was forced to reroute. adding 9 minutes to its emergency response time. For residents, these minutes represent the boundary between life and death, but the daily reality of a split town extends to routine activities. Because the train blocked the primary pedestrian routes to school, local teachers and elementary students were documented climbing through the narrow metal gaps between the stopped rail cars to reach their classrooms. To bypass the blockage, the school district attempted a temporary walk-around plan, but the physical barrier of the train remained. This practice introduces severe physical risks. Rail safety experts warn that stationary trains are never truly static. Air brakes can leak, dispatchers can suddenly authorize movement, and slack action can occur without warning. Slack action, the physical compression and release of the couplers connecting the cars, can cause a rail car to violently lurch forward or backward several feet in a fraction of a second, easily crushing a pedestrian caught in the gaps. While actual physical injuries from such climbing are rare compared to the daily close calls, the hazard is constant. With emergency routes blocked and children navigating hazardous rail yards, local officials face immediate pressure from frustrated residents. When local leaders called the railroad's emergency telephone line, they were directed to the Federal Railroad Administration's voluntary reporting portal, a database designed for tracking, not real-time emergency dispatch. The obvious question arises, why can't the local police department simply issue a citation, fine the railroad, or order the crew to clear the road? The answer lies in a complex web of federal laws that strip local governments of their traditional police powers the moment track is laid. 38 states and Washington, D.C. have enacted blocked crossing statutes designed to penalize railroads that obstruct public roads. These measures establish clear, temporal lines. In Ohio, state law set a strict 5-minute limit. In Indiana, the cap was 10 minutes. If a train sat stationary across a crossing for a single second longer, local police could write a civil citation or charge the railroad with a misdemeanor, carrying fines that reached up to $1,000 per violation. The political momentum behind these laws came directly from emergency responders and frustrated residents. Local officials argued that these time limits did not interfere with the actual scheduling or logistics of interstate commerce. Instead, they framed the statutes as a standard exercise of state police power, a necessary tool to protect public health, secure ambulance routes, and keep roads open for police and fire departments. Railroads countered with their own physical and economic realities. Trains do not stop out of malice. They halt due to sudden mechanical failures, broken signals, dispatching bottlenecks, or acute crew shortages. From the carrier's perspective, forcing a crew to split a train within 5 or 10 minutes to clear a crossing is often physically impossible and introduces serious safety risks. Bleeding airlines, walking miles of track to manually set handbrakes, and running mandatory safety tests can take hours, exposing crew members to injury in dark, remote areas. This created a direct conflict between local safety and national freight efficiency. While these state measures were officially signed into law, a stark difference emerged between a statute on the books and one that local authorities could actually enforce. The stage was set for a massive legal showdown over whether these local safety measures could survive the supreme authority of federal transportation law. When these state laws faced challenges in court, the results were almost completely uniform. Judges systematically invalidated every local crossing limit. These rulings did not mean judges believed blocking roads was safe, or that railroads had a right to obstruct communities. Instead, the decisions hinged entirely on a fundamental principle of governmental power. While a public road belongs to the town, the steel rails crossing it are part of an interstate network. Under the United States Constitution, only the federal government has the power to regulate interstate commerce. When states tried to enforce their own time limits, they ran directly into this constitutional wall. By declaring that states lacked the authority to pass these laws, courts stripped local police of their only direct lever to clear the tracks. This left communities with a startling realization. Under the law, local safety concerns must yield to a powerful legal shield. That shield is federal preemption, a doctrine anchored in specific federal statutes. The constitutional foundation for this legal shield dates back to the 1824 Supreme Court ruling in Gibbons versus Ogden, which established that Congress holds supreme authority over interstate commerce, including the physical networks that carry it. For railroads, Congress codified this absolute supremacy through two major statutory pillars. The first is the Interstate Commerce Commission Termination Act of 1995, which abolished the legacy ICC and transferred rail oversight to the Surface Transportation Board. This statute grants the board exclusive and plenary jurisdiction over rail transportation. Because this authority is complete, it preempts any state or municipal rule that attempts to manage railroad scheduling, train speed, or fleet logistics. This divides the legal structure into two distinct arenas. The 1995 Act governs economic and operational jurisdiction, while the Federal Railroad Safety Act dictates national safety rules. Although this safety system contains a narrow savings clause allowing states to enact local rules, that exception only applies when the federal government has not already legislated the specific subject. Because the Federal Railroad Administration extensively regulates train speed, brake testing, and crew hours, federal oversight is considered exhaustive. Consequently, legal precedent does not view a crossing time limit as an ordinary municipal traffic regulation. Instead, courts treat these limits as direct, unconstitutional attempts to manage rail operations. Under this layered federal architecture, a town cannot legally penalize a stationary train because doing so forces the railroad to alter its operations, violating the supreme authority of federal law. In 2018, the Indiana Supreme Court addressed this conflict directly in State v. Norfolk Southern Railway Company, case number 18 SYF 193. The state's 10-minute crossing limit had resulted in dozens of local citations. The state's highest court ruled that this restriction was preempted by the Interstate Commerce Commission Termination Act. Because the state law effectively forced railroads to alter train lengths, speeds, or routing, it interfered with exclusive federal authority. 4 years later, the debate reached the Ohio Supreme Court in the 2022 case of State v. CSX Transportation Incorporated. Ohio's law went even further, imposing a strict 5-minute limit on blockages. In its decision, the Ohio Supreme Court ruled that the state statute was preempted by both the Interstate Commerce Commission Termination Act and the Federal Railroad Safety Act. The litigation highlighted the direct conflict between municipal emergency access and the necessity of uniform national rail regulation. Ohio petitioned the United States Supreme Court for review. On January 8, 2024, the Supreme Court denied Ohio's petition for a writ of certiorari. This denial did not create a new federal crossing time rule, nor did it constitute a ruling on the constitutional merits of the preemption argument itself. In the American legal system, declining review simply leaves the lower court's decision undisturbed. The Indiana and Ohio Supreme Court rulings remain in force as binding precedent. For local communities, this procedural outcome solidified the statutory reality. State courts had dismantled the only direct enforcement tools available, leaving the federal preemption shield completely intact. A local police chief standing at a blocked crossing starts a paper trail. They dial the railroad's emergency number. On the other end, dispatchers face a logistical logjam. If a train has stalled due to a sudden signal failure, a burst brake pipe, or an acute crew shortage, the railroad cannot easily move the obstacle. Splitting the train to clear the road requires a conductor to walk miles of track, bleed air lines, and run safety tests, a process that introduces physical risks to the crew and takes hours. While the railroad scrambles, the police chief can only divert traffic. They cannot write a binding ticket. They can file a report on the Federal Railroad Administration's public portal. But that portal is a database, not a dispatch center. Its average complaint resolution time is 68 days. The FRA has safety inspection authority, but it lacks the statutory power to order the immediate movement of a specific train. Local authorities are left waiting, watching an idle engine that no outside agency has the legal power to move. A stationary freight train is rarely the result of simple corporate indifference. From the carrier's perspective, an immobilized consist is the physical consequence of a highly integrated, fragile operating system. Locomotives can suffer sudden mechanical breakdowns, severe drops in brake line air pressure, or signal system failures that automatically lock the brakes to prevent a collision. Downstream dispatch congestion can force a train to halt on the main line because the next yard or siding is full, while severe weather or track obstructions can stop operations instantly. When these delays pile up and an active crew reaches their 12-hour limit, railroads face a strict operational paradox. Moving the train even a few feet without a qualified and authorized crew is a severe safety violation. Yet, assigning a relief crew is a massive logistical challenge. Acute crew shortages and strict route qualification requirements mean a rested, authorized replacement is rarely waiting nearby. Transporting a new crew to a remote, deadlocked train takes hours, especially when relief pools have been trimmed. While splitting a train to clear a crossing seems like an obvious solution, it is not an immediate or simple command. It is a hazardous process requiring dispatcher authorization, precise, safe separation distances, and ground personnel. A conductor must walk the length of the train on uneven ballast, often in darkness and freezing temperatures, exposing them to severe ground-level hazards. After uncoupling, the crew must manually apply handbrakes on the detached cars to secure them against the grade of the track. Recombining the train later requires a complete Class 1 brake inspection and a full airline recharge, an operation that can take hours. For the railroad, stopping, splitting, recrewing, and disrupting freight schedules carries enormous operational costs, triggering cascade delays across the entire network. This leaves an unresolved division between unavoidable network constraints and the management choices that govern the rails. The persistent gridlock at rural crossings has pushed lawmakers to seek federal interventions that balance safety rules with public access. One immediate proposal focuses on information sharing. Standardizing blocked crossing reports would require railroads to log train length, crew duty status, blockage duration, and the immediate impact on emergency routes. This data would feed into a proposed federal rapid response protocol. Under this system, dispatchers would be forced to communicate the status of relief crews in real time, prioritizing clearance for crossings located on critical emergency routes. Federal legislation attempts to codify these operational changes. The D-Block Act, or House Bill 1347, proposes giving the Federal Railroad Administration limited authority to order the emergency movement of stalled trains, designed specifically to protect public safety without weakening the hours of service limits that keep tired crews off the controls. Similarly, the Railroad Responsibility Act, introduced as House Bill 341, seeks to create a uniform federal standard. Proponents argue that national legislation is the only realistic way to regulate crossings, since individual state deadlines will always trigger federal preemption. But changing operational rules does not change the physical conflict of metal and asphalt. The most permanent way to clear a crossing is to eliminate the intersection entirely. Through the Infrastructure Investment and Jobs Act, the federal government launched the Railroad Crossing Elimination Grant Program to fund grade separation projects. These massive engineering efforts, like building an overpass or an underpass, can keep traffic moving safely. One such project on Alaska's Parks Highway received $29.8 million in federal funding. For small communities, these physical fixes are financially impossible on their own. Building a single concrete overpass can easily exceed a small town's entire annual operating budget, making federal grants a necessity. Yet this solution shifts the financial burden from the private railroads to the public taxpayer. An overpass only solves the problem at one specific point on the map. It does not correct the underlying labor shortages, dispatch congestion, or long train configurations that cause blockages elsewhere on the line. This leaves communities and lawmakers facing a difficult choice. They must weigh preventive regulations on private carriers against reactive, taxpayer-funded infrastructure projects, deciding who should pay the price to keep divided towns connected. This gridlock is not the result of a single company ignoring a town, nor is it a simple legislative loophole. Instead, it is the predictable output of three powerful, legitimate systems colliding. On one side stands the Hours of Service Act, a safety law that recognizes fatigue as a literal killer. On another seats the modern, lean operating model of precision-scheduled railroading, designed to maximize asset velocity and squeeze out slack. On the third is the federal preemption doctrine, a legal shield built to keep interstate trade moving without a patchwork of local restrictions. Every part of this system makes sense to the institutions that built them. The railroad must protect its crews from dangerous overwork, and it must manage the physical constraints of heavy freight, including signal disruptions, mechanical failures, and the risks of splitting a train on dark, uneven ballast. Yet, the systemic design gap remains. A federal law that guarantees a crew the right to rest does nothing to guarantee a divided community. Rapid relief. This leaves a stark divide between physical capability and legal authority. The carrier possesses the locomotives, the tracks, and the physical power to clear the crossing, but lacks the immediate crew to do so safely. The local sheriff has the duty to protect public safety, but lacks any legal authority to compel the train to budge. As trains stretch longer and relief pools remain lean, the balance between national efficiency and local survival grows increasingly fragile. A public road can be severed for hours, emergency routes can be blocked, and kids can find their paths to school cut in half, all while every actor operates within the boundaries of federal law. How long this systemic arrangement remains defensible depends entirely on a single, unresolved question. When a miles-long train grinds to a halt, who ultimately holds both the legal authority and the civic responsibility to move it? This gridlock isn't corporate malice. It is the friction of a highly complex system. Railroads must manage genuine operational constraints, from severe crew shortages to the high risks of splitting trains on dark tracks. Yet, as federal preemption shields the rails, communities remain cut in half. The question is how we build a network where local safety isn't the transaction cost of interstate commerce. What do you think? Share your thoughts below.